Sawa. So nianze.
Yes.
Just a minute.
But particularly with the persons who were the covenants in the matter that I was handling, and
Kidogo ni convert your document to PDF nikiwa rahisi.
Okay.
Nice. So, hii session nataka kuwa more of interactive. Si ati kuna anyone who is authoritative in this section. So itakuwa ni ile mchezo wa nipe nikupe. Albert uko hapa? Tuko audible?
Yes, uko audible.
Albert confirm. Naona ma login. Albert, hausikiki?
Can you confirm if you can?
Yes, we can.
Okay.
Sawa. Na utakuwa hebu kujibu maswali?
Yes, ndio na translate lakini nafuatilia. Nitajibu tu. Rusha.
Sawa. So tunaanza na the very basic question. Mr. Ngaruya, differentiate between a bail and a bond in simple terms.
Okay. A bail takes the form of cash monetary value, while a bond can be in form of cash or a security.
Come again, I believe
a bond can be either in form of a security, where we have a motor vehicle logbook, or we can also use land title deed. But when it comes to the bail, this is in form of cash, a certain monetary value attached to it.
Okay, and where do
sureties come under bond?
In what concept?
In the concept of personal sureties. By personhood. Okay. I don't know the distinction clearly.
So let me just read it. So for a bail, this is an amount of money usually paid by an accused person in criminal proceedings after they plead not guilty, so that they do not spend time in remand during the duration of the trial. Failure to appear in court during a hearing of the case leads to forfeiture, in some instances, issuance of fresh warrants of arrest. So that is a bail. For bond is more or less an undertaking by an accused person. It is promissory in nature, and where an accused person, should they fail to make an appearance, the security bonded is forfeited. So, bail is an agreement between an accused person or his sureties and the court that the accused person will attend court when required, and that should the accused abscond, in addition to court issuing warrants of arrest, a sum of money or property directed by the court to be disposed will be forfeited to the court. I believe now the difference between a bail and bond is out clearly. For a bail, it's more of monetary terms, but for a bond, it's more of promissory nature, where a property is involved and a surety can be involved. The second question, Victor,
Yes.
give me 5 types of bail.
Anticipatory bail,
Nice.
police station bail. We have appeal, bail pending. And the court's bail, police bail, court's bail, and anticipatory bail. I have 3.
Okay. Maybe you could move on. Okay, now I think we can understand it in this way. A bail is a right at the whole process of the trial. Therefore, you can obtain a bail when you are anticipating to be arrested, which is called the anticipatory bail. Assuming you have been arrested, you are in police, you can still obtain the police bail. Then, assuming you have been presented before the judge or magistrate, and the charge has been read to you, you can still obtain the bail pending trial. That is not the normal bail. Then, after that, assuming that the judgment has not yet been entered, but you have a case to answer, you can obtain a bail pending judgment. And finally, assuming that you have been convicted or found guilty, you still have the right to obtain the bail pending your appeal in another court of higher jurisdiction. So I think we can speak about the different types of bail in the procedure of trial. All the way from plea before judgment, then after judgment, assuming appeal. Albert, in a summary manner, outline the trial process from the first step to the last step.
Can you confirm it again?
Yes, we can hear you.
Okay, thank you. The criminal trial process from the beginning to the end.
Yes, yes.
Okay. The criminal procedure process, the criminal justice process begins from when a complaint is raised. Once a complaint is raised, investigations are done, and the accused person or offender is brought to books by the law enforcement agencies, that is maybe through the police station or other agencies. Once the accused person or offender is brought to books, the report is forwarded to the Director of Public Prosecution, such that they can make a decision on whether to charge or not to charge. If it is in the view of the Director of Public Prosecution that the person has to be charged, the person is brought before court within the statutory time frame, the constitutional time frame, that is within 24 hours of arrest, save for if the arrest occurred on a period once the person is brought to court, charges are read where the accused person is expected to take plea, and if the accused person takes a plea, pleads guilty, the court can therefore enter a plea of guilty and convict the accused person on his own plea or their own plea. If the accused person does not plead guilty, that is, if he does not enter an express plea of guilty, the court will record that and it will go to the normal trial process. So if the accused person does not plead guilty, the case proceeds to the prosecution, which bears the burden or duty to prosecute the case on a bias beyond reasonable doubt. Once the prosecution gives their case, the accused person will also be given an opportunity to cross-examine the prosecution evidence and witnesses, and then the court will retire to make a ruling on a case to answer. If the court does not find that there is a case to answer, the accused person will be acquitted at that point. However, if the court finds that there is a case to answer, the accused person will not be put to defense. Here, the accused person will be given an opportunity to decide whether they would like to give sworn testimony, kindly keep confirming if you can hear me. I have said that I'm in transit.
Yes, Albert, we can hear you.
Okay. So the accused person will be given an opportunity to decide which method they would like to provide evidence on, whether they would like to give sworn testimony and so on, or to remain silent. And depending on the method that they will choose, we go to the defense case. The accused person will defend their case and also be cross-examined by the prosecution. Once the defense case is over, and now parties are given an opportunity to file submissions, then the court retires again to make a determination on conviction. If the accused person is not found guilty, the court will acquit. If the accused person is found guilty, the court will convict. After conviction, the accused person is given an opportunity to give their mitigating factors that the opposite and the aggravating factors before the court tries to now make a ruling on entrenching. Can you confirm if you can hear me?
Yes, we can hear you, Albert.
Now, when the court tries to make a ruling on sentencing, many factors here will be considered. First, the aggravating factor of the prosecution, the mitigating factor of the accused person, and also it will require some reports for correctional services, not correctional services, but probation and services. On the best way of depending on the considering the objectives of the investigation, whether it is to restore or to basically the forms of correctional services do not and now the court will come back and the sentencing the court has an opportunity to believe that the convict by now does not fall an accused enemy among the court will have an opportunity to find the convict or to imprison them for a determinate period of time or both. One sentence is done, now the accused person is taken behind the bar and given an opportunity for right of appeal within 30 days. If the accused person feels aggrieved by the sentencing, he or she can appeal on the law, or the accused person will get an opportunity to appeal on the conviction alone. So depending on the circumstances of the case, the accused person can appeal. So if the accused person does not choose to appeal, then that is when that person gets sentenced and the punishment is done. And if they choose to appeal, they will get an opportunity to apply for pending appeal where I was going to getting you up here. So they'll be at liberty yeah, they'll be at liberty pending the determination of the court. So if the court overturns or overturns the sentence or the conviction, whichever case may be, then the accused person may well be at liberty, or the conviction is sentencing like the appeal and they continue serving it. Also, there is another option which may not be upheld or set aside, but it might be varied. So if it is varied, the accused person will serve as per the variance that the appellate court has provided. Yes, so I'm almost very behind.
Yes, Albert, you have answered the question perfectly well. I know that you have mentioned the issue of pleas. Mr. Ngaruya, can you explain to us the procedure of taking plea, taking procedure, process from first step to the last step?
Yes, from the first step is where the magistrate will begin with calling out the matter, then to confirm the identity of the accused person, and then they will make sure that they know the language that the accused person understands clearly, and then from there they will ask the prosecutor to read out the charges clearly. Then they will now go back, turn the attention to the accused person and ask the accused person whether they have understood the charges that have been read before them, and the magistrate is to record the exact words that are going to be used by this accused person. Then if the accused person says that they are guilty, the magistrate will make sure that the charges and facts of the case are read out again before this accused person, and then they will record now the response that will be given by the accused person. They can even give a caution before the second time the question is being asked to this accused person, and if the accused person still says that they are guilty, the magistrate will return and give a conviction based on the guilty plea. But if the accused person decides to say that they are not guilty or uses some words which have a but, the facts are true, but the magistrate is to record a not guilty plea and set the matter down for hearing, then if the accused has the capacity also to take a plea on other types of pleas like atrofos convict, atrofos acquit, then they still have that opportunity while they are on their feet. Then from there, I believe I've answered the question concerning the plea taking procedure.
Yes, Victor, we've answered the question somehow correctly. But basically, after identifying the identity of the accused person and confirming the language that they understand, the first step is usually reading the charge itself. The offense itself now. Where now the accused person will not take the plea of whether guilty or not guilty. Then after that, the particulars of the offense are now read to them in that manner, and the procedure follows just as the way you explained. I know that Victor, you mentioned the issue of different types of pleas. If you can just outline six types of pleas. And after that, you tell us what you can do when your client, for instance, pleads guilty on the first instance of the charge, and even after the particulars are given, they have actually pleaded guilty. Number one, I'll give you two examples, two scenarios. Number one, for a misdemeanor charge, and number two, for the offense of murder. Take us through.
Okay, I'll begin with trying the types of pleas. There is a plea of guilty. There is a plea of not guilty. There is a plea of ultra-vires convict. There is a plea of ultra-vires acquit. there is a plea of presidential pardon, and there is a plea of double jeopardy, yes, double jeopardy. And then if my client takes a plea of guilty when it comes to a misdemeanor, he will just be given a fine and a conviction based on the same. But if it is a capital offense, I'll tell in this situation, am I acting as an advocate to help this person? Because if it is for a capital offense, it is dangerous to allow the magistrate to convict on the first plea of guilty when it comes to felony. I will ask the court to give another mention date or plea taking date so that my client is returned before the court to test his mental capacity, his health status, so that I make sure that when he's giving this guilty plea, he is of the right senses, in that we are not dealing with a man who is insane or is suffering from psychological traumas. But for misdemeanors, as the duty to court and as an officer of the court, for misdemeanors you will be given a fine, and of which I'll find it reasonable as compared to wasting the judiciary's precious time. Yeah.
Thank you, Victor. That is well captured. So, you need to realize that whenever it's a client who's taking the plea, regardless of the except for the capital offenses, regardless of how the other offense, regardless of whether it is a minor offense like a traffic or just you need to confirm the following: that the client did indeed understand the charges and consequences of pleading guilty. You have to inquire whether the time of taking plea or before you came on record, the client had legal representation in the first place. If not, the charges must be read afresh and the client pleads again. Then, if it turns out that the client still pleads guilty, you now go to the very important point, which is mitigation. I have not mentioned mitigation. You have to mitigate on the sentence or the fine that will be applicable. Also, if you are not satisfied with the outcome of the case, there is an avenue of an appeal. Then I can ask you, Victor, can you appeal on a guilty plea on the sentencing?
No, you can't appeal on a guilty plea.
I'm asking on the sentencing part, not on the issue of whether guilty or not.
Okay, yes, you can appeal on the sentencing part where the sentence is exorbitant or bad for making an error in law or an existing provision of the law contrary to the same. I believe to the sentencing part you can, but to the plea itself you can't. Have I answered?
Yes. Albert. What is the effect of illegal? What is the effect of illegal evidence? I'm asking, what is the effect of evidence which does not meet the criteria of legally obtained evidence? Maybe just a that illegally obtained evidence Yes, Albert, I can hear you, but maybe to make it more clear. Yes. Assuming that the prosecution in obtaining some, yes, they violate the accused rights maybe to privacy and Article
privacy
31
and
of the
Article 31
Constitution.
of the Constitution.
What is the fate of
What
that
is the
evidence?
fate of that evidence?
Okay, I was saying
The general rule is that the fate of that evidence
it
is
will
that
be illegal
it will be illegal and
inadmissible
inadmissible going into court.
However,
However,
that general
that
rule is
general rule is
subject to some exemptions.
some objections.
Some of the exemptions
Some of the
is
exemptions is
that
that
it will be
it will
admissible.
be admissible.
It won't be
It
admissible
won't be admissible.
or to the extent
But to the
that
extent that
it
it
will cause
will
prejudice,
prejudice
judge administration
judge
of
administration
justice,
of justice
and
and
violation of
violation of
subject rights.
subject rights.
However,
However,
there was no
there
any
was no any
other
other
method available
method
to appear
available
that
to
evidence,
prepare
and
that
the need to
evidence,
take of
and
that
the need to
evidence
take
is
of that
that
evidence
it
is
is going
that
to
it is going
serve
to
justice
serve justice
substantially. It might be
substantially,
admissible, so that you are very
admissible, so that
comfortable
they are
by
very
granting permissibility
granting
of such
permissibility
evidence.
of such evidence.
So I think
So I think
the question
the
is
question is to
measure the
measure
purpose
the purpose
or
or
justiciability that
justifiability
the
that
evidence is going
the
to grant
evidence is
that
not
administration of
that
the right.
administration of the
You can go and stamp the
Remember, I
evidence and
started
exact
the
definitions.
exact definitions.
Okay,
But
you see that
you see that
illegally obtained
illegally
evidence
obtained evidence
is generally
is
inadmissible,
generally inadmissible,
but not
but
without
not without
exceptions.
exemptions.
It is
It is
inadmissible only
inadmissible
when
only
it
when it
prejudices
prejudices
the case of the
the case of
accused,
the
right? That's
accused,
what you have
right?
said.
That's what you have said.
The case of the
The
accused
case of
and
the
the
accused
general
and the
administration
general
of justice
administration
given to
of
the
justice
public.
given to the public.
Because you know,
Because you know,
the
Yes, I want
subject
to,
interest must also be
must
taken
also be
into consideration.
consideration.
okay.
Okay.
Victor,
Victor,
Yes.
you represent a
you
client
represent a client
who has been
who
arrested
has been arrested
at the border of
at the
Ethiopia
border of Ethiopia
and Kenya
and Kenya
while trafficking
while trafficking
some gunias of bam.
some gunias of bam.
The plea process
The
has
plea process
happened,
has happened,
and
and
he or
they have,
she
and
has
he or
pleaded
she
not
has
guilty.
pleaded not guilty.
Orally, make an
Orally,
application
make an application
for bail or
for
bond
bail or bond
on your feet
on your feet
and satisfy
and
the
satisfy
conditions of
the
granting the
conditions
bail.
of granting the bail.
Okay, come again. Ameshikwa na gunia.
I'm saying
I'm saying
a client of
a
yours
client of yours
calls you saying that
calls you
she
saying
has
that
or he has been
he
arrested
has
at the
been
border of
arrested at the
Ethiopia or
border of
Garissa
Ethiopia or
or Somalia and
Garissa or
Kenya
Somalia and Kenya
by Kenyan
by
police
Kenyan
within the
police
jurisdiction of
within the
Kenya before
jurisdiction of
they
Kenya
can
before they
go to the other side.
go to the other side.
They have been arrested with
They
the
have been
offense of
arrested with the offense
trafficking
of trafficking narcotics.
I don't know whether
I don't know
contrary to which
according
specific
to which
question
specific
section,
section,
and now they have been brought
and now they have been brought
before the court.
before the court.
The plea process
The
has
plea
happened,
process has happened,
and they are denied
and they are
the
denied
charges. They
the
have
charges.
pleaded
They have
not
pleaded
guilty.
not guilty.
Therefore, as
Therefore,
the advocate
as the advocate
of the accused,
of the accused,
make an oral
make an
application
oral application
for grant
for grant
and outline
and
the
outline
conditions
the
in
conditions
granting
in
that bill.
granting that bill.
Your Honor, my clients before you were arrested and have been arraigned before this honorable court. And it is the law is well settled, Your Honor, that there are some conditions that the accused has to justify so that they can be granted a bail, because it is a constitutional right. And the accused is praying for this court to grant him a reasonable bail on grounds that my client has a permanent abode in Kenya, and at the time of arrest he was only making a trip to Somalia. The second condition that I will be praying from this court is to note that my client does not have dual citizenship, and there is no evidence that has been adduced before this honorable court to show that my client has even obtained a visa to visit Somalia. So he's not a flight risk, Your Honor. The other condition, Your Honor, is that my client, the accused person, is willing to cooperate with the prosecution at any given time whenever is required, and he is also amenable to conditions being attached to the bail attorney, Your Honor. I believe the prosecution have not produced evidence, sufficient evidence on why my client should be denied a bail. Thank you, Your Honor.
Nice one, Victor. But from our trial advocacy, number one, you have not introduced yourself. You need to introduce yourself. Say you're appearing for who? Who's on the other side? Then give a case. It's called casework. A case theory. Then after that, you make the application. You need to start by saying that these are right enshrined in the Constitution and a specific article you stated. And that unless otherwise proven, the client needs to obtain the bail as of right. You need to outline the conditions. My client has met this particular condition, this other conditions. Maybe you can say that the accused shall attend court and mentions and hearing unless others directed by this court. The accused shall not leave the jurisdiction of the court without leave of court. The accused shall not interfere with evidence or witness. They will not commit a crime during pendency of the prosecution. That a default in appearance during mention shall refund the bail amount to the state. That the accused shall comply with court directions. And maybe counter probable that may be raised by the prosecutor. You can even say that my client doesn't even have a valid visa, therefore is not a flight risk. You outlined that very clearly. The issue of not having a dual citizenship, that was very clear. And I believe now after you have outlined that your application is complete, you now pray that the honorable court grants your client that the accused the said prayers in the application. I think that was good. You composed yourself well. Maybe I cannot go to Albert. Albert, are you there? Now you have this question. Your client, call him Buya or someone, has insulted Mr. Kindiki, who is the deputy president of the Republic of Kenya, and are threatened to kill him in one or the other. He has been arrested. And the ODPP has charged him with treason, contrary to section 40 of the Penal Code. In your view, do these charges stand? And if they don't, give reasons. And if they do, also give reasons.
Okay, thank you so much. Number one, I believe treason is a very serious offense, and the fact that one person can threaten or insult the deputy president, in my view, does not amount to treason. First, I'll have to consider the accused insulted the president in own capacity, like as a citizen, or in his individual capacity as the deputy head of state. So the charges that are coming from Amadu, he currently being charged with the offense of threatening to kill on itself and not treason per se. Therefore, I don't believe the charges can stand.
Thank you, Albert.
Thank you, Albert.
You have tried to answer the
You have
question.
tried to answer the question.
But umeanguka chini flat. So, a closer reading of section 40, you realize that treason is only an offense when the actor's reason and the mens rea are attributed to the president of the state or the Republic of Kenya, the head of state, not any other person. So section 40 states clearly that treason is where an individual or persons compass, imagines, invents, devices or intents the death, maiming or wounding, or imprisonment of the president, not any other person. So the issue of there being a deputy president, it's just a trick to know whether treason applies to the president alone or any other person associated with the president. Therefore, now that's it. Define what treason is and give three elements of treason.
Treason is an offense committed in subordination of the state, of a state. The elements encompasses: one, it should be against the president. Two, have mens rea and actors rea.
So in any question criminal litigation, elements of an offense. The first one must be the intent, the mens rea. Then after that now, we have the actors rea, which now forms the other elements. For instance, in a treason, you have the mens rea, which is the wrongful intent. Then the other elements will be an act either levying war against the government or giving aid against the government, owing allegiance to another government, and number three, the issue of section 40 against the president. I think that's all. Albert, there is a principle called the skull or the school principle in criminal law. Explain that concept. The skull principle.
To be honest, I'm not aware of it.
You can try to save the one that I erroneously got wrong. The skull principle. Oh, sorry. I can try to salvage myself. The wind skull principle applies where there is a way that you have found the victim. There is a contradiction between the tort one and the criminal one. We really apply in both situations because I only know for tort, but for criminal, if the prosecution finds a person imekataa kutoa.
So maybe I can just chip in. So the definition of the skull principle is that the wrongdoer must take his victim as he finds him. Therefore, the fact that the victim had a previous condition that made the injury more severe is not a defense. Even if an ordinary person in perfect health would not have suffered in the same way. Think of it in this way. Someone sawa Peter, can explain the skull principle that the wrongdoer must take the victim as he finds him. Think of it in a personal grievous harm injury. You hit someone, maybe coffee, but alikuwa na shida. An ordinary slap will not make it more grievous, but because of that slap it's more. I don't know. You can just react to it if you get the concept. So it will not be a defense. You have to deep. So you must take the victim as you find him or them. Albert, are you together? Now that Peter is here, just a quick one. Maybe you can tell us what is void and how it is applied. What is a void and how it is applied.
Thank you very much for the question. A void it is a term that is used to describe what is known as a child within a tribe. So a void it is used to assess maybe witnesses to ensure on whether they are competent or not. Maybe in a children's matter or matters involving children. Maybe a judge will be forced to ask maybe a witness who is a child some questions. So as to ensure that the child understands the veracity of what is happening. Ilikuwa mwadaya na nyingine.
Peter, it was just vodaya.
Nime explain. Actually within a tribe.
Uko ndani kabisa. Just a follow-up question. Maybe you can explain the McNaughton rule in criminal law. The McNaughton rule in criminal law. Not that
So a McNaughton rule it suggests that in purposes to ensure that so it is usually applied in murder cases or maybe I can turn towards a where suspects or accused persons they have to be subjected to what we call the mental test to ensure that maybe they had the motive to ensure that is a stunt trial.
Yeah, Peter, you're trying. But the answer that you gave out that it is a kind of test that is applied to determine whether the accused person was sane at the time of committing the crime. Kama jamaa alikuwa so kichwa. Now, Mr. Ngaruya, setting sections or specific statutes.
So,
Mr. Victor,
Pluto can pass have an emergency.
Okay. Albert, Albert, are you there? Peter, I think Albert maybe you can compare and contrast between a confession and an admission, and maybe give the ingredients or conditions for an effective confession,
confession,
and you can ground it in
and you
the
can ground it in
Evidence
the
Act
Evidence
and the
Act
specific
on the
sections.
specific sections.
Thank you very much for the question. The definitions of confessions and admissions, they are very well captured in the case of
Republic
versus
Abul Fadi Mohammed,
where a confession
was defined
as statements
which are made
a confession and an admission. Kuna hii section fulani section 25. Kuna admission. An admission kuna hizo tests zenye admission imefanywa before.
Peter, I want you to assume that before the panelists, you're answering this question. So you need to build on the confidence and also the content. You started very well stating the case of Republic versus Abul Fadi. But now you need to keep that confidence in you.
Nakupata Pluto.
You can just restart.
Nimeanza kuchambua jana sasa kidogo. Nilikuwa niseme kazi za flow lakini kidogo. Akili kuna venye bado haija sinking na historia inakuaje? Mwezi kiisha fire.
Victor.
Yes.
Differentiate between an admission and a confession. Outline the legal basis. And I give the requirements for an effective confession, which is admissible in a court of law.
Okay. The Supreme Court decision, Mohammed Abul Fadi versus the Republic and others. This is where the court distinguished between an admission and a confession. For an admission in its own cannot lead to a conviction if it does not have corroborating evidence. But on the other side, a confession can lead to a conviction if it is properly taken pursuant to the confession rules. And one of the confession rules, to answer your question, is that it must be taken by a person with the rank of a chief inspector. Secondly, it can be taken it must be taken when the accused has been told that he has the right to a third party or a friend to be assistance to him or present when it is being taken. Then the accused person must make it voluntarily without being coerced, and then it must be written and signed by the accused person. Those are the rules that I can try to remember. Pluto, that is all from my end.
Have you explained the legal basis under the Evidence Act?
Okay. Yes, the Evidence Act has actually provided for confessions and admissions. Maybe are you asking on the rationales or the exact sections?
No, just the specific section.
Section 121.
No, I don't think you're correct. Section 17, which is the admissions, then we have the 25, as Peter had mentioned earlier, which defines now what a confession is.
Pluto, you are muted.
Oh, sorry. Albert, are you back?
Albert, are you back?
Okay, then you can pass it to Peter.
Then you can pass it to
Just
Peter.
a quick one.
Peter, just a
Testing
quick
your
one.
trial and
Testing your
skills.
trial and focus skills.
Together with.
Hello?
Hello?
Yes, Albert.
Yes, Albert.
Yes.
Can you hear me?
Yes,
Yes, I can hear you.
Yes, I can hear you.
Yes, I'm back.
Yes, I'm back.
Sawa, but kuna hizo nilikuwa
Sawa, but kuna hizo nilikuwa
acha
pass to Peter, acha
niende
niende
kwa
kwa Peter, then I'll back to you.
Okay, sawa.
Okay, sawa.
Amani rahisi unaweza nikia
mimi lakini.
Sawa, acha nikupatie because Albert.
So Peter, Albert,
your client has been arrested in allegations of and
has been charged with rape.
The evidence that is within the prosecution includes CCTV footage. Therefore, you are to give submissions or closing submissions on behalf of your client on the charges of rape. Can go.
Thank you. May it please this honorable court. My name is Katana Albert, counsel appearance of the.
Albert, sorry to interrupt you.
Yeah.
You will give us the
opening statement.
Then Peter will give us the closing submissions. Same client.
Okay. Shall I start?
Yes, please.
Much obliged to the honor. My name is Katana Albert. Counsel appearing on behalf of the accused. Is a case brought before you where the accused may grant with the offense of rape contrary to the penal code. Your Honor, for the offense of rape to be proved and the accused to be liable for that offense, there are several elements that must be proved. Your Honor, as you can see from the records, the evidence that the prosecution has is only CCTV footage. Therefore, the main question for determination will be whether this CCTV footage can prove to the required standard is that of beyond reasonable doubt all elements of rape. Your Honor, the elements of rape as can be established from the statutes is that one has to prove that there was no consent before the intimacy. Your Honor, I will therefore call upon this court to interrogate the veracity of that CCTV footage such that it can actually prove whether consent was obtained before a final conviction is deferred against my client. Only, Your Honor, I'm calling upon this court whether the element of penetration beyond the standard required, beyond reasonable doubt. As you can see from the record, there is no medical evidence or equivalent there, such as the criteria which can conclusively determine whether there are ambiguous penetration or not. And therefore, in light of this, I say that the prosecution case be dismissed and that the accused be free or acquitted of the offences. Your Honor, with me, is my co-counsel, Peter, who will be giving the closing remarks. Thank you.
Peter, maybe you can take over with the closing submissions.
Your Honor, appearing for the accused, in this matter, is Counsel Peter Ikua. Your Honor, before you retire to go and make a ruling on this particular matter, I'd like to remind you that sexual offense charge against a person ruins one's reputation and even in the court of public opinion. So, Your Honor, what we'll be asking you is that as you retire to go and make a ruling on this particular matter, please analyze the evidence that has been submitted by my fellow colleagues from the ODPP, and ensure that it meets the necessary threshold of beyond reasonable doubt. Your Honor, the only evidence that has been adduced was a CCTV footage which was not accompanied by a certificate of electronic evidence. And Your Honor, in the era of AI, how sure are we that it is genuine? How sure are we that it is legitimate? So, Your Honor, you will understand that the prosecution, they have not proved the case beyond reasonable doubt. And as you retire, know that you will come with a favorable ruling will acquit my client all the charges sexual because Your Honor, all the fingers they point to the accused as an innocent man. Thank you. Most obliged, Your Honor.
Thank you, Peter. Before I give my comment, I can see Albert, you can get.
Yes, I just wanted to review something on the elements which I forgot to highlight. Another element that the prosecution has to prove is the positive identification of the perpetrator. That CCTV footage positively identify the perpetrator. In this court, we have no other but to acquit the accused. Thank you, Albert and Peter.
Maybe to start with Albert.
You have done it very well.
Only that you're missing the correct approach in trial advocacy. I expected you. You remember these are opening statements. So what I expected from you
first
introduce
is to
yourself.
first introduce yourself.
Give a case. Maybe tell this honorable court that this is a case about mistaken identity of my client. At that very point, you're already painting the picture that your client is not the person who was captured in that CCTV camera. Then after that, because it's an opening statement, you don't have to go and leave the court with evidence that you are going to rely and the aim of producing that particular evidence. For instance, tell the court that we are going to be proving our client was not at that particular venue at this time, or to the fact that we have this particular alibi. Or in the alternative, the CCTV footage that is relied by the prosecutor, you are going to demonstrate before this honorable court that the person identified in that CCTV camera footage is not our client. I mean, we are just trying to prove whatever you stated your case theory is. So I think that is very well. Then you're also going to leave the court. At this particular point, you are not conducting the trial itself. You're telling the court that through this evidence, you are going to prove this. You are going to demonstrate. Also on the issue of the elements of the ingredients of bread. You need to lead the court that we are going to use this particular evidence, or we are going to dispute this evidence by the prosecutor and prove that this particular element has not been proved beyond reasonable doubt. Then at the end of the day, that's not where Peter So Peter, your role was limited to summarize what the trial itself was about. Therefore, in your closing submission, you need to first introduce yourself. You didn't. Then remind the court that we have adduced this particular evidence. We have proved this particular element, or this particular defense. At the end of the day, you are able to demonstrate that this is a case of mistaken identity. The person who is captured in CCTV, we have proved very well, beyond reasonable doubt, casted doubt in the prosecutor's case. It is not our client. It is not our client. I mean, we are just summarizing, giving a court a closing statement of what you have demonstrated. Then now call the case to rule on your favor after it retires. Maybe a thumbs up if you agree with me. Okay. Now, Victor.
Yes.
You can give the opening statement in the same case, but this side you are on the prosecution side. Prosecution counsel. And on the other end, Yes, Albert.
Maybe Pluto, I can admit that while you were explaining about opening and closing statements, I was really engaged. Maybe you can give an outline because hiyo nitaanguka.
Oh, sawa. Albert, you have something to say? No.
I was just appreciating the procedure which evaluated the opening and closing statement.
So Victor, assuming that you are on the prosecution side, as I said, the first is identifying or is introducing yourself. So you start by, may I please, this honorable court. Your Honor, my name is Pluto Balozi, acting on behalf of the state, and on the defense is Mr. Albert representing the accused, Mr. So and so. We are in court today to charge Mr. So-and-so,
Mr. So-and-so,
the accused hearing,
with
the offense of rape contrary to section, I believe,
of the Sexual Offences Act.
Your Honor, this is a case about rape. It is the right of each and every individual to have their dignity upheld by virtue of them being human. It is inherent for every person to be valued, respected, and treated ethically. This transcends further to the sexuality of every individual, but this is not the case for the accused today. The accused decided to utterly disregard the dignity accorded to the victim by forcefully and willingly coercing the victims into engaging in sexual activities without their express and voluntary consent. The accused, Your Honor, failed to uphold the sexual dignity of the victim. As this trial goes by, we are going to paint a picture of all the violent and criminal sexual of the accused were put over and above the dignity of the victim. Your Honor, we are going to prove beyond reasonable doubt and relying on electronic evidence in which we are attached certificates of electronic production that indeed the person identified in the CCTV footage matches the exact person who is before this honorable court today. Additionally, the IO, who is the officer who arrested the accused, will be called to give testimony on the handling of the CCTV footage evidence from retrieval, how the evidence changed hands until the same is produced in court today. Your Honor, the defense is going to contest the accused and the victim had an intimate relationship over the years, or in the alternative, they are going to deny that the person identified in the CCTV camera is indeed the person on the dock today. We are going to contrast that with actual evidence that were presented before the honorable court today. Your Honor, at the end of the case, we are going to prove beyond reasonable doubt that the accused is guilty of rape as we are seeking conviction. Thank you. So I think that's now the correct, or even not the correct, kind of a better way of an opening statement. You start by introducing yourself, introduce the counsel, give the case theory, then you give the court through the evidence that you're going to rely on, and lastly, now lock the case and seek for particular prayers. A thumbs up, guys, manzi. Okay, Mr. Peter. Just a quick one. One can arrest be made without a warrant. What are the conditions that you must satisfy?
Thank you very much for the question. I would like to start by saying that arrests in Kenya, they are usually the police. But we also have maybe arrest by magistrates. We have arrest by private persons, and we also have arrest police officers.
And
one thing that
arrests,
in order to maintain what we call the dignity
of a person under Article
28 of the Constitution
28 of the Constitution
is that
is that
an arrest
it
should be accompanied by
an arrest warrant in most of the circumstances.
where
These
warrant it need not to be used, and one of the circumstances
it is when
maybe a police officer
finds people
in the actual perpetrating of criminal offenses. Maybe an officer finds a person breaking into a shop, then the officer is not obliged to go and seek warrants of arrest for this person. So the officer just arrest the person
and book the person
at police station.
at police station.
The other circumstance where a warrant need not
is
during maybe the normal court
proceedings.
Or maybe in a courtroom where
a magistrate can order that certain persons who are within the jurisdiction of the court
to be arrested.
And
sina kwaga hivyo within the jurisdiction
of the court.
Anasema shika ule. No. In cases of in contempt of maybe an
advocate is
msee anasumbua kotini hapo hivyo, arrest warrant
nakupata Peter, but
grounds on the arrest can be made without warrant.
So maybe you can pass that question
to Albert.
Yes, Albert.
Okay, thank you. Let me just can you confirm it?
Yes, you are audible.
Okay. Some of the offenses that can be some of the circumstances where enforcement agencies are allowed to arrest persons without trial. Generally categorize the offenses such as those which are commonly cognizable offenses. Some of the grounds as includes where an offense is committed in the presence of a police officer and it is a cognizable offense. That officer need not to warrants of arrest for them to arrest. And then another ground which can be used is when the offender or perpetrator of the offense is trying to escape lawful custody or the arrest itself. Maybe the police officer has approached a person with reasonable suspicions that they have committed an offense, and they now results to escaping. The police officer that arrest without a warrant. Another ground is when the person tries to resist, maybe lawful confinement or something of that sort, or even go ahead and injure the police officer. In that circumstance, they can be arrested without warrant, among many other offenses. So mainly that the cognizable offenses and those which are committed openly in the presence of the police officers.
Pluto has told me that he has an emergency and that he'll come to reveal out the marking scheme. So maybe I can ask the next question. He was dealing on with a criminal litigation.
Victor, before
Yes.
you go to the next question.
Go to the next question.
Kuna hii fulani bado officer
When an officer, maybe Masai usiku,
sees you at night and
reasonable apprehension.
You are about to commit an offense.
I believe that one applies to the highways.
Highways.
Yeah. If it's in a highway, you will be arrested. You will be arrested in highways at night. So, the next question, because Pluto will come to clarify, can a private person participate in a criminal proceeding on behalf of the prosecutor if it's a criminal matter? Can the victim himself participate in criminal cases on behalf of the prosecutor? Albert Char.
Can you repeat the question?
Can a private person act on behalf of the prosecutor in prosecuting a matter? In this case, he is the victim of a criminal offense that has been committed to us.
Yes, possible. However, the person has to make a special application before the court, which is called an application for private prosecution. And the person has to demonstrate to court why they will not prefer the state person or the prosecutor to proceed with the prosecution of that case. The court will consider those grounds, and some of those grounds will just to highlight them. Dissatisfaction with the way the prosecutor is handling the case, or maybe professional misconduct or relativity from the part of the prosecution, or if the private citizen can prove to court that the prosecutor has a conflict of interest with the accused person. Once the court is convinced and those grounds have been established to the required standard, the person will be granted an opportunity to personally prosecute that matter through counsel or themselves. So basically the general rule is governed by private prosecution proceedings. So allowable and is acceptable.
Thank you, Albert, for that. So maybe I can clarify from my end so that Pluto can also clarify from his end. One, you have gotten it right that you need to seek consent from the DPP, and you must show that in court now, after making an application to the DPP, and it has maybe been granted or refused to approach court, you make this oral application before court, the victim, you tell them that your main role is not coming to replace the prosecutor because the law will not allow you to replace, but the law allows a private entity or a private person to act alongside a prosecutor, and to an extent that they can even contribute in doing submissions if they have appointed a counsel. So at least you have correctly understood that private prosecutions exist in Kenya. Yeah.
Thank you, Victor, for that. My next question will be
directed
to Mr. Ikwa. And it's a very simple application that I want you to make orally. A written application, but now you make it oral. Like the components. You just give the components of what is required in that particular application and what you must prove. So Peter, during the 2024 demonstration, one of your closest friends has been arrested by the police. The last time you saw them, they were in a Mariamia Central Police Station, KBZ 001H. Days have passed and they have not been arraigned in court. And whenever you visit the cells, you are unable to get their access. So, highlighting the correct procedure and the pleadings to file, make an application to have your close friend arraigned in court, or he be produced. And are not to give ingredients that must be in the application for it to be allowed.
Thank you very much for the question. Like to say that Article 25 of the Constitution, it provides the right to an habeas corpus. That will be a habeas corpus application. You are demanding release of a person from maybe a public institution, which is the police. So I will make an application. I will go to the court through maybe chamber summons, and I will move through a certificate of urgency, a chamber summons plus supporting affidavit. I'm on court particulars.
Like you're making the application. As you know, you're making the application. You're writing it, but you just highlight it orally. What you're going to do. That's the basis of it. You can be asking borrowers. What are the ingredients or particulars of a chamber summons applications of habeas corpus that has high chances of being allowed.
Itakuwa hivi pale Republic of Kenya Republic of Kenya I state the parties, maybe the name that is me. That is me, who is the applicant. Then I'll be having the respondent, which is the National Police Service, the AG. I'll also include
the DCI
as a party.
Then the enabling provisions. Let all parties concerned appear before this honorable court for the hearing and determination of Pluto, just pass it to anyone else. Wacha ni pass to Alberto. You can pass to Victor.
I only know one, that you must show that this person disappeared while in the custody of the police. Like you want to prove to court that you verily believe that this person is being held by the police officers. That was my contribution.
But Pluto sijapata swali yako.
But Pluto sijapata swali yako. Unauliza particular kama ni kila stage, yani tuseme kama unasema unataka ku through chamber
So
sound.
Peter, basically what I wanted, Peter, you just tell me that you are going to move the court,
ya chamber sound.
the applicant will be
you,
and the respondent will be now the
OCS of that particular police station.
The AG, the National Police Service. Then after that, I expected you to tell me the principles, like whatever you are going to prove now in that because there are particular ingredients that you must prove in order for that application to be allowed. Number one, you must prove that the person or the subject disappeared in the unlawful custody of the respondent. For instance, if it's during the mandamano and your client or your close friend just disappeared, you can't point out exact person whom your close friend disappeared. Then the court will not be able to order or allow the application for habeas corpus for the obvious reason that the court will not give orders which are tunazihitaji.
Production.
Yes, Victor.
Production orders.
Like orders are
like orders are
I mean, the court will not give orders. The orders will be
the reason that the orders will be effective.
Like haitakuwa na haja, itakuwa
kama kupeana tu orders za bure.
So you need to point out the exact person whom the subject was last seen with. Then number two, that person must be within the jurisdiction of the court. So when you're moving the high court, the person was last seen in Kenya. If it happens that there is evidence the accused person was moved out of the jurisdiction of Kenya, the orders won't be given. Then lastly, you can even challenge detention. If the person has been detained, but unlawfully, that. So those are basically the grounds that I wanted you to prove or show the court. That these particulars grounds have been satisfied. Therefore, my application and a certificate of urgency should be granted. So in the application of expert chambers, yes, Albert.
Now just proceed. My question regarding this particular question.
Okay. So basically, Peter, I expected something like that an order of habeas corpus being issued directed to maybe the OCS to produce before the court the body of your close friend. These are the courts. That's immediate release of that close friend at the cost of the application. Then the parent of the close friend. Yes, Albert. I think that issue is now settled. Albert, you can go. Albert, are you speaking?
Yes, I'm speaking. Can you hear me?
Thank you. Muted.
I'm saying the question that you had asked before you got an emergency, I was just standing for it. Give us the comprehensive answer.
The comprehensive answer of?
There's a question, in fact, you asked just before you left, then Victor took over, one question on private prosecution. So the question before private prosecution is you who can ask the answer when you got an emergency.
Wow. I'm just asking random questions.
No, they are random. Can you recall it?
I can clarify the question that was asked by Pluto was on various offenses that one can be arrested without a search warrant, an arrest warrant.
Yes.
Oh, yeah, I get it.
I get it now, Albert.
So, I think those are the offenses which are they are called cognizable offenses, whereby the arresting person
whereby the
or the
arresting
officer
person
has
or the officer has reasonable
belief that
belief that
the action being conducted
the action
amounts
being
to an
conducted
offense.
amounts to
They
an
are
offense.
particularly provided for
They
under
are particularly provided for under
28,
section
29 of the Criminal Procedure Code,
29 of the Criminal Procedure
whereby
Code,
an arrest can be made
whereby
without a
an arrest can be made without a warrant.
number one,
When
a
number
person
one,
commits
a person
breach of
commits
peace in presence
breach
of a
of peace
police
in
officer.
presence of a police officer.
That's a cognizable offense.
That's a cognizable offense.
A person
A
obstructs
person
the police
obstructs
officer
the police
from
officer
conducting his
from
duty, maybe
conducting
arresting
his
or
duty,
the
maybe
duty of the
arresting
police
of
officer.
the duty of the police officer.
The other thing is when a
The other thing
person
is when a person
tries to escape
escape
custody,
lawful
maybe from the
custody,
prison,
maybe from the prison,
kutoka cell,
trying
to kuhepa, then
kuhepa,
an arrest can be made
then
without
an
warrant.
arrest can be made without warrant.
When a person is in
When a
possession
person
of
is in
something
possession
that
of
the police officer
something that the
believes
police
that
officer
has been stolen,
believes that has been stolen.
when a person is reasonably suspected to
reasonably
be a
suspected
deserter from an
be a
armed
deserter
forces,
from an armed
they
forces,
can be arrested.
they can be arrested.
Causing breach of peace. I don't know
Causing
whether I
breach
said
of
that.
peace. I don't know whether I said
I
that.
believe I said.
I believe I said.
Someone being caught in a
Someone
public
being caught
place
in a
in
public
wee
place
hours and
in
failed
wee
to give
hours and
explanations
failed
on
to
what
give
they are up to,
explanations on
and
what
the
they are
police
up to,
officer has
and the police officer
reasonable belief
has
that the
reasonable
people or
belief
person
that the
is
people
about
or
to
person
commit
is about to commit
an offense.
an offense.
So I believe those are good examples on when an
good
arrest can be
examples on
made
when an
without
arrest can be
warrants.
made without warrants.
Then I think we should also
Then I
remember
think
that
we should
an
also
arrest can
remember
be
that
made by a
an
private
arrest can be
person,
made by a private person,
but there is a
but
condition that
there
we
is a
must
condition
surrender that
that they
person
must surrender that
to the
person
lawful arms
to the lawful
for
arms
rearresting.
for rearresting.
And lastly,
And
a
lastly,
magistrate
a magistrate
can also arrest
can also
when an
arrest
offense
when
is
an
done
offense is
within
done
when a cognizable offense
when a
is
cognizable offense
done in their
is
presence.
done in their presence.
For arresting person,
For
the
arresting
force
person,
must be
the
reasonable.
force must be
Same with
reasonable.
the
Same
police
with
officers.
for police
For a
officers.
magistrate can
For a
just
magistrate can just
direct the person to be arrested,
direct the
or he
person
or
to be
she
arrested,
can actually
or he or she
arrest.
can
So I
actually
believe Albert
arrest.
needs your
So I
arrest
believe
without
Albert
warrant.
needs your arrest
Iko
without
now
warrant.
home vizuri.
Iko now home vizuri.
Yes, thank you so much.
Yes, thank you so much.
I had scheduled something to
I
begin
had
immediately
scheduled
at
something to begin immediately at
7:30 based on the
7:30
representation
based on
that was
the
made in the group. So,
representation that was made in the
in
group.
case
So,
I leave any
in
time,
case
I'll
I
just follow the
I'll
proceedings.
just follow the
It's okay. We are actually ending
It's
because I
okay.
will
We are
schedule our
actually
meeting
ending
to
because
run
I will
from
schedule our meeting to run
6 to
from
7:30.
6
I
to
think I have
7:30.
overstayed my
I think
welcome.
I have overstayed my welcome.
Therefore, if there are no comments,
Therefore,
I
if
think we
there are
can
no
end it there.
comments, I think we
Pick
can
it
end
up
it there. We'll pick
there
it up
from tomorrow on a different
there from
issue.
tomorrow on a
Maybe
different
ukitaka comment,
issue.
I can see
Maybe
my mute.
ukitaka comment, I can see a mute.
Ni ile kidogo.
Ni ile kidogo.
Nikiingia kwa hii station ilikuwa zile discussion yani.
Zile discussion
Kwa hivyo hapa azin sio unakuja kama umesoma yani
unakuja kama umesoma yani points.
Hata azinaka tu ni yani unafai
Azinaka tu ni yani unafai
unauliza maswali na panel.
Unauliza maswali na panel.
Exactly Peter, you know.
Exactly Peter, you know.
Mimi nadhani tu unajibu venye.
Mimi nadhani tu unajibu venye unadai yani.
Hebu tuambie ile point ya.
Hebu tuambie ile point ya.
Hebu kwanza tukumbushe ile point.
Hebu kwanza tukumbushe ile point tunaona.
Sasa acha
prepared 24/7, and I think this is the best approach.
ni challenge. Kuna mwenye nilikuwa kizungu nikani nilikuwa nimeifungia, sasa hiyo acha kabla niongee kizungu bana, acha ni
Sasa Peter, I think
sawa.